Officer Dave, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Who's this? Paulina Brown, this is you have an 11 o'clock. Why are you here? Good morning, ma'am.
Good morning,
What is your name?
Paulina Brown.
Your case is at, are you also known as Paulina Calvin?
Yes.
Your case is at 11 o'clock, ma'am.
Okay.
You want me to put you back in the waiting room or remove you?
You can remove me, Your Honor. I'll come back at 11.
All right.
Thank you.
Yes, ma'am. Good morning, Councilman.
Good morning, Your Honor. How are you?
I'm not bad. How about yourself today?
Good, good.
What
I'm here.
file do you have today with us?
787.
Taylor Park versus Thomas Andrews.
Yes.
I have
Yeah.
him. Let's get you started.
Okay.
787. All right. As soon as he connects, we can get started.
Okay.
What is your name, sir? He's connecting still.
Yes,
What is your name?
Thomas Andrews.
We are on the record calling file number 20166-787. Taylor Park Townhouses versus Thomas Andrews. This is date and time for an objection to garnishment filed by Mr. Andrews. Your appearances.
Good morning, Your Honor. Robert Zelinski on behalf of plaintiff P69250.
And you are Thomas Andrews?
Correct.
Sir, you are the moving party. What is the basis of your objection to garnishment?
Well, at this present time, we had a lot of problems at the apartment complex. There was a lot of things that wasn't took care of. And when we was leaving out, we was kind of under stress as far as money wise, because we on a fixed income. I have a monthly check that they are trying to garnish that I do housekeeping for only $800 some. And it was me, my mom's and my aunt in the place, and they on SSI right now, and they only getting 8 something a month. So it was kind of hard at the time. Plus, they didn't do a lot of the things they needed to do. That's my complaint. That's not
Do you have any other basis for your objection to garnishment?
none other than being slow for work for COVID, and that's the only, like I say, source of income that I had coming in
Mr. Zelinski.
that they trying to garnish.
Yes, Your Honor. I'd say he's probably either attacking the judgment or looking for payments. I'd say there's no grounds for his objection. If he wants to give me a call at my office later this afternoon, we could talk about payments and suspend the garnishment, have that discussion. But as far as grounds for this, I don't think there's any legally.
Yeah. Mr. Andrews, financial hardship is something that we all recognize is a reality, but it is not a basis for a valid objection to garnishment. Objections to garnishment can only be based on defects in the writ of garnishment. For some reason, the garnishment proceeding is invalid. You may not use the objection to garnishment proceeding to attack the underlying judgment. You have failed, sir, to state a valid objection to garnishment. Your objection to garnishment must therefore be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. As counsel indicated, you can call his office. You can talk about working on a plan, or you can file a motion with the court for an installment payment. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Morning, Counsel.
Good morning, Your Honor.
What file are you here on today?
I am here on Ms. Shaquille L. Smith. I'm representing sure. Gotta
You
get
represent the plaintiff.
Asset Acceptance Solution LLC. I'm getting old, Your
All right.
Honor. I'm not young.
Consider the alternative. Getting old is a good thing. Let me see if I have your other side yet. I have somebody here who has not identified themselves. I don't know who they are. It could be your other side.
All right.
Hello? She's connecting up.
Okay.
Failed connection.
I often wonder how they get involved in these things. Perman Warren contacts a firm in California who contacts me in Lake Odessa when they could do it themselves. I don't understand, but that's all right.
All right. What is your name, ma'am?
Shaniqua Smith.
Okay, we are on the record. This is 07112-980. Asset Acceptance versus Shaniqua Smith. Date and time for objection to garnishment. Your appearances.
Appearance Michael W. Septon, P1320 on behalf of Asset Acceptance LLC.
And what is your name, ma'am?
Shaniqua Smith.
You are the moving party. What is the basis of your objection to garnishment?
Well, this is not my account, Your Honor. So I did submit a what do you call it? Identity theft. This account was cleared up through DTE back in 2013 for fraud. So I've never lived at that address.
Do you have any other basis for your objection to garnishment?
I'm sorry, say that one more time, Your Honor.
Do you have any other basis for your objection to garnishment that you haven't told me about?
Oh, no, sir.
Sir, your response.
May it please the court, if the DCE should have contacted Asset Acceptance Corporation because they believe it's a valid debt when they purchased it, I suggest she needs to do some communication between DTE and Asset Acceptance Corporation to get them to do what's necessary, because right now she can't attack the underlying judgment until that's cleared up. And apparently nobody ever sent a dismissal of that case. So I'm kind of stuck in the middle.
Yeah, ma'am.
Yes,
Michigan Court Rule 3.101K, which governs objections to garnishment, is pretty clear. You may not use the objection to garnishment to challenge the validity of the underlying judgment. In this case, you were personally served with summons and complaint back in April of 2007. When you failed to respond, a judgment by default was entered against you on July 7th of 2007. That judgment was renewed, given it life for another 10 years on April 10th of 2017.
I was not personally served anything,
Excuse
Your
me,
Honor.
again,
Oh, I'm sorry.
you may
I don't
not
know.
use the objection to garnishment to challenge the validity of the underlying judgment. And that's what you're attempting to do here, ma'am.
It's not my debt.
Okay, I'm done.
I just don't understand. That's all. It's,
Well, if you don't understand, perhaps you should listen and not interrupt me.
oh, wow.
Consider the possibility that I might be able to explain to you if you stop interrupting. As I indicated to you, Michigan Court Rule 3.101K says you cannot use the objection to garnishment, which is the only matter before the court today, to say there's something wrong with the underlying judgment. Your claim that it was not your case, your claim that it was not, you were not solved, are both attacks on the underlying judgment, specifically prohibited by Michigan Court Rule 3.101K. Further, the court has been provided with apparently a police report that you filed in June of 2022, several years after the judgment was renewed in 2017. And in that you said between 2003 and 2004, unknown persons opened an account with DTE using your information. The court finds you failed to state a valid objection to garnishment, your objection to garnishment must be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in Wayne County Circuit Court. The court will send out to both of you an order. Thank you both for coming in. I will move you now at this time. Thank you, counsel.
Thank you, Your Honor. You have a blessed day. It's always hard when they don't understand the system or don't perfect it.
Yeah, she's trying to do something she can't do.
Yeah, considering when I was pulled in law school, we have over half the world's attorney in the United States. It's not like we're not on every corner. Hell, we got more attorneys than we got gas stations.
That's true.
You
Have a good day.
You have a blessed day, Your Honor. Thank you.
Thank you, sir.
Okay, let me see. Get here.
Counsel. Good morning.
Good morning, Your Honor.
Ma'am, what is your name?
J. Roche Harris.
We are on the record calling file number 20160-978. The file is entitled Phoenix Property Management versus Jerisha Harris. Date and time for objection to garnishment. Turn your camera on, ma'am, please. Let's get started with your objection. What is the basis, ma'am? You are the moving party. What is the basis of your objection to garnishment?
First of all, I never knew that they were ever suing me for this property. When I stayed there some years ago, I was in contact with the property management person who they put over the property that I was in, and she let me know when I was moving out that I wouldn't be punished or anything for moving. I stayed in contact with them the whole time I was there and when I was moving out. And I just never knew that they were ever even suing me for this.
When did you move out, ma'am?
It was March, I think, of 2019.
Okay. Is there anything else you want to tell the court?
That I just literally cannot afford for them to be taking 25% of my paycheck every 2 weeks. I don't make that much for them to be taking that. It's like I'm not even working the hours that I work, and I can't afford it.
Okay. Mr. Gotholz.
Well, Your Honor, the grounds that Ms. Harris stated do attack the underlying judgment. I will point out that there was personal service of the summons and complaint before the judgment was entered back in 2020, and funds were collected in 2021 from a tax garnishment. But she is attacking the underlying judgment, which is prohibited by court rule in objections to garnishment. So as far as the garnishment objections are concerned, there's been no valid basis stated for them, and I'd ask that they be denied.
All right. Ma'am, Michigan Court Rule 3.101K is quite specific on this point. The rule provides that you may not use the objection to garnishment, which is the only matter before the court today, to attack the validity of the underlying judgment. Financial hardship is something we all recognize as a reality, but is not a valid basis for objection to garnishment. You have failed, therefore, to state a valid objection to garnishment. Your objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. You have the right, if you choose to do so, ma'am, to file and serve a motion for installment payments. If the court grants your motion for installment payments, it would prevent your wages from being garnished. You would have to serve a copy of that on the other side. 14 to 16 days after the motion is filed, the court will make a decision. I'll send out an order to both of you today denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Good day.
Double Nichols Symphony, the music of Francis Symphony number 55. Antal Dorati and Philharmonia Hungary. And we just heard here, Christmas supported WRCJ FM HD News. WRCJ was provided by Ote Harris Greek Tech announcing a band of chamber music entitled Sunny Breeze. Sunday, June 26th at 2:30 p.m. Ote Harris Chamber Ensemble will be performing musical throughout the brand. Seating. There's no admission charge and free guarded parking is provided. Gotcha. Weekday music. Oh, the drive time elixir. Classical music is great for the car. Classical music from 5 a.m. to 7 p.m. on WRCJ 9.9 and 10. Thanks for the support. 90.9 Detroit, Windsor, and Ann Arbor, Detroit's only all classical and jazz music station. There is an amenity on classical and jazz. WRCJ, tell your smart speaker to play WRCJ. We take our music everywhere with a free app from Google Play or the App Store. Richard Edgar was in charge of the Academy of Ancient Music and chairman of the performance of the musical Kendall, and Mr. supported WSCJF. The Paris release of this opera was called Jerusalem. Italy. That was Lombardy, 1847. Giuseppe Verdi. There's ballet music from the French version of that opera. Crusaders are French, there's ballet. Thursday, 27 Celsius. 9.9 FM. CJ.
Morning.
Good morning, Your Honor. How are you today?
I'm good. How are you?
I'm doing fine, thank you.
What brings you today, sir?
We have a debtor exam of Miss Linda Strickland.
Linda Strickland. Okay, let me see if she's here. I'll have to query a couple of people. Let's see who they are. I have a couple of iPhones. Let's admit them to see who they are. Hello?
Good morning,
On the iPhone, what is your name?
Marnita Calvin.
Okay, put you back in the waiting room. And on the Galaxy A20, what is your name? No audio. Hello?
Hello,
What is your name?
Maxwell Lamb.
All right, Mr. Lamb. All right, you stay there. Mr. Bratzy, I'm going to put you back in the waiting room. I don't have your opponent as of yet.
Thank you, Your Honor.
Morning, counsel.
Morning, Judge. How are you?
Good. We are on the record 21-241-063. Maxwell Lamb versus Baseline Automotive. Date and time for pretrial. Your appearances.
Your Honor, Lionel Bayshore for Baseline P58599.
And what is your name, sir?
Maxwell Lamb.
All right. Where are we on our written discovery, gentlemen? Are we done?
Your Honor, Mr. Lamb has provided me about 6 or 7 pages. A couple of them are duplicative, I presume. This is all he's going to offer me in response to the discovery request I've made, which is basically just asking him for all of his documents and any expert reports that he had that would support some causal connection between what he's complaining about and the work done by my complaint.
Mr. Lamb, do you have any other documents in response to the request for discovery that you're going to send to the other side?
I sent what I thought was I had available.
All right. Here's what we're going to do then, gentlemen. This is our this is our 4th pretrial. I'm going to give you one more date, and I'm going to close discovery at the time of our next pretrial. The next day we will be together, gentlemen, will be July 20 at 11 o'clock. Does that work for everybody?
Yes.
July 20, so that's about 28 days.
Yeah, Mr. Wednesday, like today.
All right. Yeah, that's acceptable to me, Judge.
All right, July 20th at 11 o'clock. And your discovery will close July 19th.
Okay.
Is there anything else we can accomplish today, gentlemen?
Your Honor, just clarification, housekeeping issues.
Sir,
And admittedly, ignorance on my part, but 36th District Court's policy on written disclosures.
in regard to what?
Typically, when we are filing actions, we have to file disclosures if we're a plaintiff, and of course, as defense, we have to file our counter disclosures, identifying witnesses, documents, things of that nature.
Okay,
Does 36th District Court have such a policy?
You're talking about MCR 2.302A disclosures.
I am, Your Honor.
The rule provides that they're only required in the circuit court unless the district court requires them. In my practice, since I typically open in non-PIP cases, written discovery, I only require 2.302A disclosures in PIP cases.
Okay.
But in cases like this, I simply open your written discovery.
Got it.
Okay?
Last issue, Your Honor, is obviously, I presume after discovery is closed, I just want to make sure that I keep my eye on when this court will hear motions for summary disposition. Is there a particular date the court will set to hear those types of motions?
What I would suggest you do, if you plan on filing such a motion, get it filed before next time we're together. And then when we're together, I can set a time that's agreeable to all. But the court will provide, you may file a motion for summary disposition at any time. And I'll simply calendar it if we don't have any more things scheduled.
Very good, Judge.
All right?
Thank you,
Thank
sir.
you, gentlemen.
Thank you.
Have a good day, Judge.
All right, let's be safe out there.
You too, Judge. Thank you.
All right, we're gonna go off the record.
Shit. He heard that, didn't he?
Yeah, I heard it. Hello? There we are. Counsel?
Good morning, Your Honor.
Morning. What brings you here today?
Looks like we are up for a debtor's examination this morning.
Okay, what is your name, ma'am? What is your name, ma'am? Are you Renita Payne? I have somebody who identifies themselves as Renita Payne here.
Payne.
What is your name, ma'am?
Yes.
Hello? Renita Payne, are you there? All right, I'm going to put her in the waiting room and try to bring her back. Maybe we have a problem with our connection. All right, let's try it again.
Can you hear me now?
I can hear you, but I can't see you. Turn the video on. Your computer is freezing.
My video was on. Let me try to start it again. Your computer is freezing. Okay, I'm gonna try to do it from my phone.
All right, ma'am, can you hear me now? I don't seem to have her. I have a video and that's, what is your name, ma'am?
I'm trying to do it from my phone right now.
There's a problem with your connection.
I can see everything.
I can see someone who's labeled Renita Payne. I do not have video. I have a frozen video. I have no audio. If you are helping Ms. Payne with the need to re-examine your connection. There's something wrong on your end. Sound. Your video is displaying a frozen picture, and there's something wrong with your sound. Your audio is off. Check your connections. Can you hear me now, ma'am? This is going nowhere. There's something wrong with your connection, ma'am. I'm going to adjourn this matter for 2 weeks, and you need to get your connection organized. I'm not going to take council's time anymore. We can't have a debtor's examination. We can't hear you.
Are you experiencing any sort of fragmentation in my audio like that, Your Honor?
No, I am not.
Okay.
And I've done my morning call, and I've had both lay people and attorneys, and I've had no fragmentation at all.
Okay.
It's on her end. It's something, I don't know what it is.
Okay. So 2 weeks from now?
Let me get my calendar out here.
Okay.
Today is the 22nd of June. So that would be July 6th. Does that work for you, counsel?
Yeah, that's just fine. 11 a.m. again, Your Honor?
July 6th at 11 o'clock.
Okay, we'll be here.
I'll send out notice to both of you.
Thank you, Your Honor.
You're going to have to do something with your audio, Ms. Payne.
No.
No, it's fragmenting.
Yeah.
Check it.
So I just disconnect, Your Honor?
I'm sending out a message.
Oh.
Okay, counsel, yeah, we're done. All right. This is file number 21240-532. Kalina Calvin versus Marnita Calvin. Your respective appearances.
Good morning, Your Honor. Attorney Jessica Warfield, P85391 on behalf of defendant Marnita Calvin.
And what is your name, ma'am?
Marnita Calvin.
Ms. Warfield, who are you representing?
I am representing the defendant Marnita Calvin, Your Honor.
Okay, she's here. Paulina Brown, mute yourself.
Kalina Brown.
All right, so you're representing Marnita Calvin, Ms. Warfield?
Yes, Your Honor.
All right, so I'll mute her since you're here. All right, this is date and time for two things. We have a pretrial and we have a motion concerning discovery.
Yeah.
Ma'am, Ms. Brown, did you get the motion concerning discovery?
I did. I got it. She emailed me that day. Mine,
Yeah.
I had sent.
Did you
my
file an
lawyer.
answer to it, ma'am?
My lawyer, I had already had that from my lawyer. She sent it, well, my previous lawyer, and I thought she gave it to them because I did that questionnaire already with my lawyer.
Ms. Warfield?
Your Honor, to my understanding, again, going back to, I believe, the hearing before last, Ms. Brown now, because she has gotten married, was represented by counsel. We exchanged discovery. I sent discovery to Ms. Brown's previous counsel on March 31st. She received it on the last hearing, the same hearing in which Ms. Brown's previous counsel made a motion to withdraw. It was discovered that Ms. Brown did give some things, or the answers to our discovery request to her previous counsel. However, her previous counsel indicated that what she gave, or the format in which she gave it in, wasn't compatible to be sent over to myself nor the court. And according to Mrs. Brown's previous counsel, that previous counsel requested her to resend it. And I guess that was never done. Again, we sent our request in March March 31st, 2022, seemingly 3 months later, and we still have nothing, Your Honor. This case is almost a year old now, and
Yes,
we would like to find a resolution quickly.
getting too old.
Yes, and we're still waiting on plaintiff's discovery, Your Honor. Discovery
All right.
first.
Now, ordinarily, I would just move forward on this. But given the fact that we've had the change of counsel and Ms. Brown going from represented to unrepresented, do you still have the, you can send to her the discovery requests?
Yes, Your Honor, I can resend them.
Yes,
right.
I do, Your Honor.
And here's what we're going to do. I'm going to order that by the time of our next pretrial, which will be July 20th.
Your Honor, I will be out of the country that day. I can't have someone else from my office cover though, if that is okay with the court.
Yeah, because that's what you're doing today. Hill is attorney of record, as I recall.
No, I am the attorney of record, I believe. It may have been changed, I don't know. But either way, someone from our office will be handling.
Okay,
No
this is
problem,
what we're
Your Honor.
going to do. I'm going to go to July 20th at 11 o'clock.
Mhm.
I'm going to enter an order providing Ms. Warfield that you will serve your written discovery forthwith. I will send to that same order, Ms. Brown, will require you to provide full and complete responses to that discovery by the time of our July 20th pretrial. The idea is that by the time we are here again, today, Ms. Warfield is going to send out to you another set of the discovery requests. Your answers will be served and filed by July 20th. You
Yes,
must make the discovery. If you don't make the discovery, then she's going to move to dismiss the case.
Okay.
All right.
Your Honor, may I give you my new address? Because I
Let me do this.
Email.
I'm going to put you into a chat room where you can give her your new address. The reason I'm not doing it here is that we're on the internet and literally you don't want everybody in the world to know your address.
Yes, sir.
All right, July 20th.
Thank
Each
you.
of you will get 2 orders. And then we're going to put you in the chat room and get that other information.
Okay. Thank you.
Your Honor.
Hello?
Yes, hello.
What is your name?
Linda Donaway.
Are you also known as Linda Strickland?
Yes.
All right. Then I think, counsel, we have both sides. Let's call the case. We are on the record calling 11115-084 West Michigan Debt Collection versus Linda Strickland. This is the date and time for a debtor's examination. Ms. Strickland, do you have video?
No.
All right, raise your right hand.
Okay.
You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, I'm going to put you two into a chat room, and you will answer the counsel's questions under oath.
Thank you, Your Honor.
Okay.
Good morning, ma'am.
Wait, let me get started. Let me get you there.
I'm all set, Your Honor. Thank you very much.
All right, thank you, sir. Have a good day. Let's be safe out there.
You too.
Thanks. Bye-bye. That's going to conclude our docket for the morning.